Good afternoon. I'm Mary Lee Anderson on behalf of Senior Services in Alexandria and the Alexandria Bar Association. I'd like to welcome you to the third and final session of the 9th Annual Senior Law Day. We're very excited to be able to present this event in a virtual format. And of course, we never imagined how relevant our theme this year was going to be when we started planning this event months and months ago. Our panelists will be sharing important information that will help older adults decide, should I stay or should I go? Housing options as we age. Before I introduce this week's panelist, I'd like to go over a few housekeeping details. The event is being recorded so that we can share the information with you at a later date. Please put any questions that you have in the Q&A box and be sure to get them in as early as possible so that the panelists can get to your questions at the end of their presentation. Please don't put questions in the chat box because we're going to be monitoring just the Q&A box. You should find that right at the bottom of your screen. Everyone registered for this event will receive an email with links to the presentations and other important resources, which will also be posted on SSA's website. Now I'd like to introduce you to our two panelists. Gretchen Meinken is a partner with the law firm of Wade, Grimes, Friedman, Meinken, and Leischner. They're located in Alexandria. Ms. Meinken focuses her practice primarily on the areas of estate planning and estate administration and is licensed to practice in Virginia, Maryland, and the District of Columbia. Mary Horner works as a staff attorney in the Alexandria Office of Legal Services of Northern Virginia, representing low-income, elderly, and disabled residents of the city in housing, consumer, and elder law matters. Mary's active in the Alexandria Bar Association. Both she and Gretchen helped plan this event. She serves on the board of directors for both the Bar Association and the Alexandria Law Foundation, and also participates in several Bar Association committees. She also serves on the board of directors of the Dunbar Alexandria Olympic Boys and Girls Clubs. Now, let's get started. Gretchen and Mary will now be sharing the screen. Take it away.
Thank you, Mary Lee, and good afternoon, everybody. I hope that all of you were able to tune into our prior two presentations, both last Friday and the Friday before. And today we will be focusing on estate planning and other documents that you will be that are necessary when you're looking at the estate planning process. Can we already go to the next slide, please? All right, so let's go ahead and get started. Let's talk about the 4 documents that we're going to be talking about today. The first one is the Advanced Medical Directive, the General Power of Attorney, your last will and testament, and then a revocable trust. And Gretchen will be talking about that primarily. Next slide. So Advanced Medical Directive, what is it? An Advanced Medical Directive, it governs who can and cannot make medical decisions on your behalf when you lack the ability to make an informed decision. The important part of that is lack the ability to make an informed decision. An Advanced Medical Directive does not take effect until you are unable to make your own decisions or you lack capacity. How do we make that determination? That determination is made typically by 2 doctors. That's usually the provision that is included in an Advanced Medical Directive. So 2 doctors will have to determine that you are unable to make your own informed decisions on your medical care. If 2 doctors do not find that, then you still, in terms of making your own decisions, have capacity to do that. By completing an Advanced Medical Directive, you are giving an agent the power to handle your medical affairs. Basically, they stand in your shoes as if they are you and can make decisions that you would otherwise make if you were not incapacitated. So, decisions on your health care, what surgery if it's necessary. Typically in the Advanced Medical Directive, you do set forth your preferences, including preferences for organ donation, if you want your body to be used in a scientific experiment or an experiment, a study, anything like that. So those are all, this is a place where you can put down your wishes in case you are not able to express them yourself. You can also, again, address preferences on life support to avoid the Terri Schiavo type scenario. Next slide, please. As you're all aware, with today's COVID climate, this document is more important than ever, especially when it comes to life prolonging measures, whether you want them or not. One thing that's incredibly important, whether it's with your agents or just your family members, make sure you express what your wishes are to them. It's really important to sit down with your family members and your friends and someone you would like to serve as your agent and talk to them. Let them know, what your wishes are when you get to a point where you cannot express them yourself. It's just really important, especially right now. I did want to just talk briefly about some of the signing requirements, since that's been coming up quite a bit during COVID. It's a bit more difficult for us all to get together in person, which is why we're doing this virtually right now. But there is a witness requirement for an advanced medical directive if you're going to have it signed in a written document. So there's no notary requirement under Virginia law, but there is a two-witness requirement. If you cannot afford legal representation, one thing I want you to be aware of course, is I work for Legal Services of Northern Virginia. If you qualify for our services, this is a document we can assist you with, a simple advanced medical directive. You can also go ahead and look at the website listed on here to see some samples of those documents and what they look like. When you do have an advanced medical directive, you can upload it to the advanced medical directive registry, which is also listed on the screen. And I also highly recommend, of course, giving copies to your agent and also to any doctors that you have. Next slide, please. So now we're going to talk about a general power of attorney. This is often considered your financial power of attorney. This is what handles, deals with money. This document sets forth who can make financial and business decisions on your behalf or take actions on your behalf, pay your bills on your behalf, doing something to assist you in handling your financial matters. It is important to remember that the agent that you select, so whoever you designate as your agent in your general power of attorney, they do have a fiduciary duty to act in your best interest. One question I often get is, well, if you're giving someone access to money, can they just use it on their own? No, this money is still your money and your finances still belong to you. So your agent is required to still act in your best interest as if they are you. This does not somehow become your agent's finances. You often hear the word durable power of attorney or general durable power of attorney. That word durable, what this really means is that this does not, the power of authority that you are giving to your agent does not terminate if and when you potentially become incapacitated. Let's say you fill out your power of attorney, you have an agent who is assisting you in paying some of your bills, and then you get to the point where something happens and you become incapacitated. Rather than needing to go get a guardianship, your agent, if they have a durable power of attorney over to assist you in your affairs, that power of attorney is still valid, even if you are incapacitated yourself. That's what that durable means, if you hear that word. Typically, a power of attorney, it's valid and effective upon signing. That's typically what we recommend, is you want to be able to have your agent help you now, unless it specifies that a future date it becomes effective. We often call this a springing power of attorney. And why would you want a springing power of attorney? We generally recommend not using it because a springing power of attorney takes effect generally if and when you become incapacitated. We'll talk about that a little bit more in a second. Can we go to the next slide? Like I was saying, some of the issues around the different types of powers of attorney. If you have the non-springing power of attorney, generally the durable power of attorney, your agent is able to, again, act immediately. They can assist you in your finances, paying bills immediately. One of the issues that comes up with this is just making sure that your agent, whoever you select, is someone you can really, really trust, because you are giving authority over your finances. And again, that agent does have a fiduciary responsibility and a duty to you. However, if you don't fully trust someone, that it could potentially be abused. So make sure that when you're thinking, who do I want to serve as an agent for me, that you select someone that you trust and that's trustworthy. What about issues with the springing power of attorney? Like I said before, generally a springing of power of attorney does not take effect until you become incapacitated. And it can be quite difficult if you get to that point. Let's say you've lost, you're incapacitated and you have a family member who is now, oh, well, I need to somehow make this power of attorney become effective so I can then help my family member pay their bills. The bills are racking up and I can't access their funding. I want to help them. It can be a little bit difficult and more time consuming for that family member or whoever else you select to be your agent, for them to then go ahead. They usually have to get a doctor's evaluation, sometimes 2 doctor's evaluations that say you in fact are incapacitated and cannot make your own decisions. And sometimes capacity is not quite clear. Again, and then, if it's not clear, and having a third party accept that you are in fact, your agent is acting under good authority and that you are incapacitated can be a little bit tricky. So that's some of the issues and why we generally recommend going with a durable power of attorney. Next slide, please. Yes, so I did want to highlight a few differences. There is a difference between having someone act as your financial power of attorney and having them added as a power of attorney to one of your financial accounts, your bank account, versus having them added as an owner or a joint account holder. Those are 2 different things. If they are simply a power of attorney and they are added as an agent on your account, they do not take an ownership role in that account. They just are provided a signing authority. So they can access your funds to help pay your bills, but they do not somehow become an owner of that account. If you add someone as either a joint account holder or an owner of the account, they then become basically a joint account holder with you. They have the same rights to that funding. They can spend it, if they wanted to, they could spend it on their own needs. It also could open you up to creditors. And that's one thing that I always warn people about. If you have someone added to your account that is not necessarily have the best credit, or if they've had issues in the past with creditors, your bank account could then be subject to garnishment or other collection action if someone is seeking money from your joint account holder. So it's just something to be thoughtful of when you are, trying to add someone either as an agent or an owner on a joint account holder on an account. Just be thoughtful in how you set that up. If you do make that person a joint owner, that account would automatically go to that person when you do pass away. So it's just, again, something to be thoughtful of. And again, do not rely on the bank to advise you on this. Next slide, please. Yes, I'll let you guys enjoy this funny picture for a second. We want to avoid this. Next slide, please. Yes, so now we're going to talk about your last will and testament, your will. This is a written document. This a lot of people don't understand. Your will does not take effect until you pass away. It is a document that is for the future. This is something that you use to dispose of your property after you pass. In this document, you can state burial preferences. This is where you name your executor and who will ensure that your wishes are followed. And if you happen to have any minor children, you can name a guardian for them. Next slide, please. So how do we create a will? First, you, the testator, need to be over 18 years old and mentally competent at the time that you create it. You also have to have witnesses that are disinterested, so you can't just have 2 family members sitting around looking at you. You need to have 2 disinterested witnesses who are also 18 years old and mentally competent. Then you will have the will drafted, recommend with an attorney if possible, and then the will be signed by the testator, you, in front of the 2 witnesses, and then also a notary. and it needs to be signed by both witnesses. This is one of the biggest struggles right now that we are having with having individuals execute and sign wills, because it is a process that takes a team of sorts. You need to have several people together, you know, to make this happen. So that is one of the issues that we're having right now. Just wanted to point that out. So there is a self-proving affidavit in Virginia you can use. With a self-proving affidavit, the two witnesses basically attest that that you are in fact over 18 years old, that you were signing of your own free will and you were not forced to do it, and that you as the testator are competent and of sound mind. The purpose of this is to shorten the probate process, which Gretchen will talk a little bit about in a bit. Next slide, please. So some more information on how it is created. So you will, as the testator, will select an executor who you will name in your will. This executor needs to be someone who is over 18 years old and mentally competent. It can be anyone you know or trust. It does not have to be a family member. It can be a friend, anyone who you trust to carry out your wishes. If you do not name an executor, or if the executor is unavailable, the court will appoint what we call an administrator to go ahead and serve as that role. You can also have more than one executor or co-executors, two people who work together. Sometimes having co-executors can make things a bit more difficult. Things get more complicated if you have co-executors. So sometimes it is, if you're going to name more than one person, it's wise to have a primary executor and then a substitute in case that first executor is not able to carry out the duties. Next slide, please. So to whom may I leave my property? You can leave your property to pretty much anyone you want, an organization. You can leave it to relatives, friends, pretty much anyone you want. You just need to be aware of what it is you're giving away and make sure that it is something that you are able to give away, which I'll talk about a little bit more in the next slide. But you do just need to be a little aware of the fact that if you're married at the time of death and you do not provide for your spouse, they will be entitled to a portion of your estate. Just need to be thoughtful of that. Next slide. So a will, like I said before, your will govern what happens to your probate assets. I will talk a little bit more about what probate means in the next slide. But in order to address your probate assets and begin the process of administering your estate, your will have to be admitted to the court where you last resided at death. And an estate will be opened and your executor will be appointed by the court or an administrator. And then the estate administration will follow. Next slide. This is what I was talking about earlier, probate versus non-probate. This can be a little bit confusing. So probate assets are those assets that are in your individual name and for which you do not have a beneficiary designation in place. These are your assets, whether it's a bank account that has no one else named on it. If you own property in your own name with no one else listed and it doesn't automatically go to someone else, that would be considered probate property that you will dispose of through your will. Non-probate property. These are things that are not disposed of in your will. These are assets that either have a beneficiary designation or they're owned by another person with a right of survivorship. These are not governed by your will, and these are not disposed of within your will. Some of examples of this, so property co-owned with a surviving co-owner with a right of survivorship. Let's say you and your spouse own property together with a right of survivorship. When you pass, your property is not a probate property that will be disposed of in your will. That is something that will automatically go to your spouse. Let's say you have a life insurance policy. Oftentimes, you're asked to fill out a beneficiary designation. That beneficiary designation makes your life insurance not subject to probate. It is a non-probate asset. It doesn't need to go through that probate process for your life insurance proceeds to go to your beneficiary designation. So there are ways for some property to not be handled in the probate process. Next slide. So it's also important when you are completing your will to be aware of if you have any real property, if you have a home, a second home, anything like that, just be aware of how it's titled, and not necessarily who's on the mortgage. So you're going to have a deed of trust, but also a deed. Those are two separate documents, and you need to look at your deed to see how it is legally titled. How your property in the deed is titled is going to affect whether or not it is probate property or not. There's three types of ownership that we primarily see. So solely titled in your name. If you don't have any beneficiary designation there, of course, this is going to go into your probate. It's going to be considered a probate asset. Jointly owned with right of survivorship. Like I said before, if you have a spouse and you have right of survivorship, that is going to be a non-probate asset that will automatically go to the surviving spouse. And then there's jointly owned with no right of survivorship. In Virginia, that is often referred to tenants in common. Again, so that would actually, we need to know that because that would then go back to your probate asset. Next slide. So I'm going to hand it over to Gretchen to just finish up this last part of the will and last will and testaments, and she's a little bit more familiar about the estate administration process. All right. Thanks, Gretchen.
Thanks, Mary. Good afternoon, everyone. So estate administration process here in Virginia, the average estate is going to take about 1.5 to 2 years to go through that process. It can be longer, it can be shorter, rarely shorter, but it all depends on the assets. It depends on some complexities that may arise. So keep in mind that it can be a lengthy process. When we start the process, when your will actually gets recorded with the court, your executor qualifies before the court, and your executor's role is part of their job is to file an inventory reflecting date of death value of assets, and typically an annual accounting until all the assets have been distributed from the estate. So the process can be costly. It just depends on the situation, but you will always have court fees. You will always have probate taxes, which are assessed by the state of Virginia. If you hire an attorney, which is normally what your executor will do, your executor will have attorney's fees that are paid from your estate. And if your executor is not a Virginia resident, then they are required to be bonded by the state, or required to be bonded by a private surety company by the state. So like a Liberty Mutual or any of those types of companies. So that's enough. Those premiums are also expenses of your estate. Things that can occur with estate administration, if we have any minors inheriting, that will throw a huge wrench in it because they cannot inherit directly under a will until they are an adult. And so there are situations where we may have a guardian ad litem appointed for them. We may have a guardian of the property appointed for the minor. There are lots of different issues that arise. The last will and testament, your last will and testament will actually become part of public record. So it is searchable by anyone who wishes to go into the courthouse and look. They can find it pretty easily with your name. So your inventory is going to be included in that, and all the accountings, those are all public record and can be seen by the general public. You can avoid probate with a revocable living trust, and I'll delve into that in just a second. Before I move on to trust, I know we had a question here from Mr. Fadden about what, and I'm going to backtrack to advanced medical directive, and the question was, what happens if there's no advanced medical directive at the time that you need assistance? So the state of Virginia actually has a code section on this, thankfully. It is 54.1-2986. And what it says is that whenever a patient is determined to be incapable of making an informed decision, that's that whole language that we talked about earlier, and they don't have an advanced medical directive, or none of the agents under their advanced medical directive are available, then what your physician is going to actually go through a list of priority of people that can make those decisions for you. So first they start with a guardian of the patient, and that's the guardianship conservatorship thing we're going to talk about a little later. Then the patient's spouse, then an adult child of the patient, then a parent of the patient, then an adult brother or sister of the patient, and then any relative of the patient in a descending order of blood relationship. And if there are none of those people willing to step in, then they can just go to someone who is either a director, employee, or agent of a healthcare provider currently involved in your care. That person cannot, however, make a decision on withholding or withdrawing life support. So Obviously, the goal is to have an advanced medical directive so we can avoid this situation, but there is basically a contingency in case that occurs. So I'm just going to mark that off as answered. So now we're going to roll into trusts. So next slide, please. So a little brevity. A lot of people ask, well, now that I have this living trust, what am I supposed to do with it? And this is kind of, this cartoon spoke to me because it asks, what do I feed it? So you feed it your assets. That's the answer. But it is obviously more complicated. So next slide, please. So the way a revocable living trust works, a revocable living trust, what it is used, the purpose of it is, it's used in conjunction with your last will and testament. So you still have a will when you have a trust, but they work hand in hand. So your will is going to say, I leave everything to my trust. And its role is to kind of be a backstop for assets that you forgot to transfer into the trust or that you didn't transfer in for whatever reason. So our goal is to try to avoid or at least minimize the probate process with a trust. The will is going to, it's the benefit of the trust over the will. So like I said earlier, the will is actually recorded. It becomes a public record. Anyone can see it. A trust is a private document. It is like a contract. It is not recorded with the court when you pass away. The court's never involved unless there's some litigation involving the trust. So the assets in your trust are private. All the language in it is also private. Next slide. So how does it operate? So the trust is an inter vivos trust. Latin, we're attorneys, we like Latin. So what it means is that it comes into being when you sign the trust. It becomes a breathing contract the minute you sign it. So it's not waiting until your death before it becomes into existence. During your lifetime, it uses your social security number. So it is your alter ego for tax purposes. Any asset that's in that trust that earns interest or dividends, any type of income, gets reported on your normal 1040. The IRS is ignoring your trust until you've actually passed away. You are generally the trustee of your own trust, which means you are in control of the assets just as you would be normally. You can add assets, you can remove assets, you can modify documents, you can do all sorts of things. It is a very flexible contract. With the whole purpose of the trust we talked about earlier is retitling. So we either want to retitle assets into the trust or we want the trust to be the beneficiary of assets. There is some complexity when we're dealing with retirement assets, and that is where meeting with an attorney is highly recommended because retirement assets have some different rules associated with them. So one of the questions I have here on the Q&A from someone is about retitling real estate into a trust. So we generally recommend you see an attorney to prepare your deeds. I appreciate that there are online services that you can use where you fill in the blanks. The concern that we have with those is we have seen what happens with those documents when they are improperly done. And it's a lot more expensive to clean up that mess than to just get it done right the first time. So real estate, we actually deed it into your trust. It is a warranty deed. I think that was one of the specific questions. So whatever warranty you currently have on your property, we normally move that same warranty over to your trust. The document actually has your name, comma, trustee, and the name of your trust as the new owner. So that would show up in tax assessments as well. But that is how retitling works. You do the same thing with financials. You can move certain financial assets into the trust, and you would use those assets just as you would normally. Retirement assets are the ones that we typically talk about with beneficiary designations, as well as your primary checking account, because you've probably got a lot of auto bill pay and auto deposits all set up, and we don't really want to tinker with that. So we normally will let you just do a payable on death or transfer on death designation on those assets to your trust to avoid you having the pain of moving them around. Like I said before, the document is revocable. So you can modify the document as things change. So you can change beneficiaries, you can change who your successor trustees are, you can do a variety of things. So that's kind of that's the beauty of the document. So I think I addressed the first question on the real estate. The second question was, let's see, what happens to your real estate if with regard to trust and will. And so this is an anonymous attendee. I'm not sure who it is, but what I'll say is if you have a trust, you should put your real estate into your trust. If you don't have a trust, then your will govern what happens to it. So your will govern who inherits that property. So depending on what structure you have, that is something that needs to be considered. So again, I would say, if you're not sure and you have a trust, it was probably created by an attorney, I suggest you call that attorney or talk to another attorney that you wish to speak with. Next slide, please. So what happens when I lack capacity? So like I said, you're the trustee, you're in full control of the trust and the assets in it. What happens if you are determined to lack capacity, and usually the trust agreement is going to reference how that's determined. Typically it's similar to your advanced medical directive in that we're asking for 2 doctors to say you lack capacity. So in that scenario, then your successor that you named will then take over managing those assets going forward. The income is still reported on your individual tax returns. What happens when I die? So your trust will, basically the date of death, your power of attorney terminates. So let's just go ahead and put that out there. The power of attorney stops, so nobody can use that anymore. Your trustee, your successor trustee will then step into your place as the new trustee, and they'll get a new taxpayer ID for your trust, which will then have its own tax filing requirement. Your trustee and or executor will also be dealing with your final 1040 returns. Your trustee will then administer the trust based on the terms in the trust agreement, which you've put in there. So it's going to be, operate a lot like a last will and testament in terms of it will dictate who gets what assets, when they get it. You know, if there's certain ages that you don't want someone to receive money before, it does all of those things. If there is a supplemental needs trust or some type of special needs trust, it will work with that as well. Next slide, please. So one of the issues that we come up with trusts, just as with estates, minors. So the issues that come up with a minor inheriting under a will or by beneficiary designation, because I see this all the time. The court or the financial institution are going to require a legal guardian of the minor's estate be appointed by the court. Varies by jurisdiction. State of Virginia, it's going to require a petition. It's going to require a guardian ad litem, which is a third-party attorney who's going to basically evaluate everything, and then a court order. So it's not a short process. It's not an inexpensive process. So the funds are restricted during the period of guardianship, so until the child turns 18. Virginia has all sorts of rules about that. There's also going to be annual accountings required with the Commissioner of Accounts for that jurisdiction. There's going to be a surety bond for the guardian for every year, so premiums every year that the guardianship is in place. The court fees every year while it's in place. And then when the child turns 18, they get the money outright regardless of their financial maturity. Next slide, please. So the difference with minors inheriting under a trust is that you, the trustee and the grantor of the trust, can actually dictate when they get money outright. So if you think it's more appropriate for them to get it when they're a little older, you can schedule that in the trust document itself. Until they get the money outright, the assets can be used for their benefit for a variety of purposes in the trustee's discretion. The court has no involvement in the trust, so there's no legal guardian appointed. So we avoid the entire court proceeding on that prior slide I just talked about. And then assets with beneficiary designations can actually name the trust of which the minor is a beneficiary to avoid the legal guardianship in that scenario as well. Next slide, please. Before I jump to this one, sorry, there's a question about who needs a trust. So that is a very broad question. What I would say is that my best suggestion is that you schedule a consult with an attorney, and what that attorney is going to ask to know what assets you have, how they're titled, what your intentions are with regard to who should inherit, when they should inherit. They're going to take the entire picture of your assets and your life situation and figure out what's most appropriate for you based on those. Most of the times they'll give you some options as to which way you can go and the pros and cons of each. That is my suggestion. There is no one set rule as to who should have a trust and who shouldn't. It is not based on the value of your assets, as some people think. It is based on the totality of your circumstances. So we have, let's see, we'll get to some of these other questions later. So adult guardianship and conservatorship, one of the issues, so you're going to ask, what is it? So when you lack capacity, if you don't have an advanced medical directive and you don't have a power of attorney in place, no one is legally able to act on your behalf, with the exception of that statute under the advanced medical directive that we talked about. No one can act on your behalf. So a bigger issue comes into play with your money. So nobody can pay your bills, nobody can, pay your mortgage, do any of those things on your behalf because they have no legal authority to act for you. So if you don't have those documents in place, we have to go through an adult guardianship and conservatorship process in order for someone to take over those roles. So the process starts when a family member or someone else involved in your life is going to petition the court to seek to have a guardian conservator appointed on your behalf. A guardian is going to have control over you physically, so your medical decisions, where you live, things of that nature. Conservator is going to have control over your financial affairs. So Virginia, we bifurcate the roles. They do two different things, but many times it is the same person serving. So once that petition is filed, the court appoints a guardian ad litem to act as an independent third party in the case. They are an attorney, so they're typically pretty well versed. They volunteer to be on this list with the court, so they've usually done it a few times and they're ready to take it on. During the proceeding, you are going to be subjected to a physician's evaluation to determine your capacity. And so if you don't willingly subject yourself to it, they can get a court order forcing you to subject yourself to an evaluation. And what we're looking for is, do you have the ability to manage your financial and personal affairs? So your GAL is going to review your assets, they're going to talk to your doctors, they're going to talk to your family members, they're talking a whole investigation here. And then what they do is they write a report to the court detailing what they've heard, what they've seen, and what their recommendations are. The court will then determine whether to appoint a guardian conservator for you and who it should be. Next slide, please. So who pays for the proceeding? You do. So long as you have assets, you are paying for this. And assuming it was brought in good faith. So this isn't just some random grandchild who's decided they want your fortune and they want to take control and try to force the issue. This is, if they brought this in good faith, meaning there have been signs that you're incapable of managing your affairs, then your estate, your funds are paying for the court fees, all the attorneys involved, and the guardian ad litem. If you do not have sufficient assets, the state of Virginia picks up the tab for part of it. So I will tell you the average guardianship conservatorship case is going to be anywhere from about $7,000 to $10,000. So just having your advanced medical directive and your power of attorney can avoid that cost. All right, so huge cost savings. So what happens if a guardian conservator gets appointed? So you're going to lose a number of rights depending on your capacity issues, to include your right to vote, your right to marry, your right to drive, your right to own a firearm. These are all things that can be negotiated in the proceeding, but understand that they can all be taken away. And that's because you are deemed incapacitated by the state of Virginia. Your guardian conservator is going to make decisions concerning your medical care and financial affairs going forward. They are required to work with you and to try to make decisions with you. Their job is not to take over for you, but they have authority to do whatever they need to do. But they do need to consult with you and try to work with you and figure out what's best for you and what you want. So keep that in mind. The guardian conservator will generally remain in place until your death unless you recuperate from your incapacity or whatever you're suffering from. They will be required to file annual reports with the court. So conservator is going to file annual accounting showing what funds you had, what's happened to the money over time. The guardian has to file accounts with a separate division of the county or the city to discuss where you are with your medical, what type of treatment you're getting. Next slide, please. So how can I avoid this type of proceeding? as I said before, advanced medical directive and a general power of attorney. The court wants the least restrictive method. These two documents are your least restrictive method. The court loves it when we have this, all right? So because nobody wants to take away your rights. Nobody wants to do that, and nobody wants you to have to spend to have the petition, the pleadings, all of that done. They don't want you to have to pay the court costs. So that is your easiest and most cost-efficient means of avoiding this. The other document that can also help can be your trust, because what happens is any assets that are in your trust when you become incapacitated, your successor trustee can step in and manage those assets for your benefit without any court involvement. So we're not needing a guardian conservator. It's not even a part of that proceeding if we have to go that route. I will tell you, we have seen an uptick in these cases, and that's stemming from aging population, lack of proper estate planning, and also we've seen a lot of elder abuse situations where people are being scammed. So these are all kind of tying in together at the same time. Next slide, please. So online software, see it all the time. There are a number of online companies with software available for you to use for a minor fee. Obviously very cost effective, but the issues that we're seeing. The provisions are pick and choose. So while they were crafted by an attorney employed by that company, nobody sat down with you and tried to figure out what you actually need. They are leaving it up to you, the consumer, to pick what you need without knowing the interplay between the provisions. So a lot of times what we have is language that's missing, language that's poorly written, that's going to cause litigation. So those are the biggest things. In fact, we have a case right now that has something similar going on. It's expensive once you start doing litigation over language. Okay, so this is going to apply primarily to a last will and testament. When people do their own, there can be severe complications without you knowing that there are going to be complications. And that's going to be, you may not realize, unless you went to the seminar, that you don't want minors inheriting anything under your will, because then we have guardianship of the minor's property. You may be inadvertently giving money to somebody who is getting government benefits, and what they inherit under the will you drafted is going to kick them out of eligibility for benefits. So there are lots of things that come into play. And that's why I appreciate that attorneys are expensive. Legal services in Northern Virginia can do estate planning documents for you if you qualify. And that's something that Mary is fully versed in. There are, some things you can do yourself online, but I would suggest that you at least try to talk to an attorney. Many attorneys will offer you a complimentary consult to talk about your situation. I suggest you take advantage of that, and because it's going to cost a lot more if things aren't done properly at the very onset. Next slide, please. So as takeaway from all this, estate planning is critical for a number of reasons. It avoids unintended consequences. So this is that whole thing about distant relatives inheriting your estate. It happens. I have one of those cases. Very distant relatives are inheriting assets because there was no will in place. So the laws of intestacy say that if you don't have a will, then the laws of intestacy kick in, and it's basically your family tree. We're going down your family tree, then up the tree and out until we find living bodies. So you could have some random second cousin that you've never met inheriting all your assets. Estate planning, it sets out who manages your affairs, so you get to pick who's making decisions for you rather than the court. It minimizes the burden on your agents. And so this is something I want to highlight. It is not an honor or a privilege to be named executor of an estate. It is even more cumbersome if you don't have a will, because somebody in your family is now going to have to track down where all your assets are, what you have, all your debts. This is in addition to them having a job of their own, right? So whether you have a will or you don't, the person who's going to step up and take this on already has a life of their own with family, job, all of that. So this is a second job for them. So appreciate that that's why I say this is not an honor and a privilege. It's a job. And that's why they actually are entitled to compensation for the work that they do from the courts. So having things laid out as to what you want to happen benefits you, and it benefits the people that you love who are stepping into these roles when you need them. And of course, as we've mentioned before, estate planning, it's the best way to avoid expensive court involvement in proceedings. So that's going to be estate administration, minors inheriting, guardianship, conservatorship. I can safely say it's a lot less expensive to plan properly ahead of time than to deal with those matters when you don't have documents in place. Next slide. So we're going to do a Q&A in just a minute, but my information is here. The next slide, please. And this is information on how to reach LSNV. That's where Mary works.
Yes. And I just wanted to highlight there. So as Gretchen recommended, yes, of course, we do recommend talking to an attorney. I just wanted to clarify that LSNB, we cannot give any advice on whether anything about trusts. We can't tell you whether or not it's appropriate for you or not appropriate. We just don't have the training. So I do recommend, if you are able to take advantage of one of those free consults with a private attorney, if you have any interest in a trust, that would be the best place to start, just because they can really tell you whether or not that's something that is appropriate for you. And we don't have the capacity or capability to really make that determination. But we can assist in drafting, a simple will or a simple power of attorney or advanced medical directive.
So Mary, one of the questions that we have here is whether Virginia Legal Services qualifications are based on income.
Yeah, so traditionally, yes, but when it comes to documents like this, it's a little bit different. It's more so a cap. So if you have a second home, you probably will not qualify for our services, or if you have a certain amount in assets, I actually don't know the exact amount, but I believe it's either $25,000 or $30,000. If you are above that, we just blanket recommend speaking to a private attorney at that point, because that's probably getting to the level of potentially needing a trust.
Okay. Mary, I have the Q&As up. So.
Oh yes, I do too.
All right. So I think one of the questions from Ms. Demick is, what's the process of transferring conservatorship of a spouse from Tennessee to Virginia? Would it require incurring legal fees for attorneys and a guardian ad litem, I think is what you mean. So the process of transferring from another jurisdiction is like a ping pong match. So Tennessee has to issue an order saying that they are willing to release guardianship. Virginia, this is a tentative order of willingness to release guardianship. Then Virginia has to issue an order saying that they are tentatively willing to accept guardianship. And then Tennessee has to issue a final order saying that they're willing to give up guardianship. And then Virginia has to issue a final order saying they're willing to accept guardianship. So it goes back and forth for several months. So you need an attorney in both jurisdictions. Generally, there's not a guardian ad litem appointed so long as the issues that are it's a straight transfer of guardianship conservatorship to a guardianship conservatorship. So it's going to depend on the circumstances, but you will need an attorney at both locations. Do you have any you want to take, Mary?
Sorry, I was kicked out for a second, so I'm just getting that set up again.
So I think I answered the
so
question.
what if you have a subsequent will that does not have two witnesses? And correct me if I'm wrong. Well, the fact that you use subsequent suggests there is a prior will that was presumably signed with witnesses and a notary. I have some concerns that it would not be valid if there was a subsequent will or some addition, a codicil or some addition to your will. My concern is if you don't have the newer will following all of the requirements under Virginia law, this might not, when the time comes, someone's going to look and say, well, this one's not valid. We're going to go with the prior will that was signed, and it has the notary and the witnesses. So I would have concerns that it would not be recognized as valid. Do you agree, Gretchen?
Yes. So, I mean, if you have a typed will, so it's done on a computer,
right.
It has to be signed by the testator. It has to have two witnesses. So the notary is on that self-proving affidavit,
right.
which is also what the witnesses and the testator sign. And the reason we have that self-proving affidavit is we want to avoid having to track down your witnesses to a will that may be dated 25 years ago, to have them provide basically a deposition that all the formalities of signing a will were complied with, that they were present, everyone was in the same room together. It's a whole big ordeal. So that's why we have that self-proving affidavit. So if you have a subsequent will that doesn't have two witnesses, and this is a typewritten will, if it doesn't have two witnesses and a notary, then, and there's a prior will that you have the original will that has all those things, you can submit it all to the court when someone dies, but the court is going to reject that will because it's lacking the formalities. Doesn't mean you can't overcome that with a court order, but understand that obviously my guess is that subsequent will is somehow modifying what people are receiving.
Right.
So all of the people that would be impacted by the change have the right to hire counsel and fight that change. So
Right.
it becomes very problematic.
Yeah, and I think the greatest gift you can give is clarity, because the whole point of the will is to make clear what your intentions are, and if you have two competing documents and one has followed the formalities and one has not, you really do run risks of the fight, the fights that can occur after you pass. So
the next question is, do household furniture and other tangible items pass automatically to your spouse? So let's start off with, you don't have children from prior relationships. So if you have children, they're children together. Your spouse, if you don't have a will, then the laws of intestacy would come into play, which means your spouse would inherit everything in that scenario. So yes, they would get your furniture and your other tangible items in that scenario. If there are children from prior, so if these are your assets and you have a child or children from a prior relationship that has not been adopted by your spouse, then your spouse is going to actually split those items. Your spouse has some ability to file for certain elections against the estate, which would include tangible property. So you get a little more complicated. So again, this is where we say it's always better to have a will, to have that clarity in there. Okay?
right, and I think this really just it highlights why seeing an attorney is so important, because our presentation today is really just a very brief overview of the documents, but just the analysis that Gretchen just went through demonstrates that each situation is different and more and complicated, and so it just, again, it really highlights the reason why you need it. I recommend seeing an attorney.
The next question on the list is from Mr. Schuster about how to fund the trust. So again, we already talked about put your house in there. I generally don't recommend the car because it's problematic with dealing with the DMV. There are alternative means of moving a car from your name to a trust after you've passed that don't involve probate. Bank accounts I touched on already. Retirement accounts, I mentioned that those are complex, and that's why I would recommend you talk to an attorney about that, because anyone who's doing this would also understand the tax implications, I think a little more in depth than this presentation is for, but I'd be happy to answer you if you wanted to give me a call after the fact. What happens if a minor beneficiary lives in the UK? So the estate would be based here in Virginia. So Virginia law is going to govern. So they would require that a guardianship of the estate of the minor be opened here in Virginia for those assets. It's possible they would let us simply pay it into the general receiver or some other mechanism, but that requires a court order. So not a simple process, but the laws of Virginia are going to govern because your estate is here in Virginia.
Mary and Gretchen, we have time for just one more question.
Oh, that's hard.
I think here's one at the very bottom that I'm looking at. I have will, trust, etc. Do I need a POA on checking accounts in the trust? I think you mean, so if you have a checking account in the name of your trust, then you don't need a POA because your successor trustee can access that account if something happens to you. If you have a checking account that's in your sole name, then you should have a POD or a TOD on that account to move it to your trust on your death. And your agent under your power of attorney would have access to that account until you die to use it for your benefit.
I'll let you do one more because you answered that one so quickly.
Oh,
To be honest, I actually don't know the answer to the first one about whether or not your primary care provider can be your agent under your advanced medical directive. I think we'll need to do a little bit more research on that one. I just don't know the answer off the top of my head. That's the first time I've had that question.
so I generally, I've had this before, and what I would say is you need to talk to your primary care provider
Right.
to see if they can ethically
Right.
serve in that role.
Yeah.
And that's, I can't tell you whether the law doesn't allow it, but I can tell you that you need to talk with them first. Now, if you name a company, so if you name the practice itself, the advanced medical directive statutes in Virginia do not permit that. Some places will still take it, even though you have that basically an entity name, they'll still take it. But we have seen or heard of some medical providers refusing to accept it because it's not a person. And the way person is defined in that particular statutory section does not include a business or an entity, which is unlike most other statutes in the state of Virginia that define the word person. So.
Right.
You're muted, Mary Lee.
I'm unmuting. There we go. Now we're going to have to wrap it up. Mary and Gretchen, I just want to thank you both so much for sharing this important information. As I mentioned at the start of the hour, everyone registered for the event will receive an email with links to the presentation, and you'll also have some other important resources that'll be posted on SSA's website. I want to also show you this handy dandy little book, which is the Virginia Bar Association's updated version of the Senior Virginian's Handbook. It's a wonderful compilation of legal information and resources. We have lots of hard copies of the handbook here at our office, and they sit right outside the front door, so you don't even have to have any personal contact. You can just come to our office and pick them up. They're also at the 4 Alexandria libraries in the senior information corners. And our office is open every day for weekdays from 9 to 4. We're located in Old Town at 206 North Washington Street, Suite 301. We hope that you've learned a lot over the past 3 weeks and that you've enjoyed the virtual format. I think it has a lot to offer. It really provides a more personal connection in some way, and everybody can hear all of the information without any problems. If you're interested in learning more about how the Alexandria government works and the many resources available for older adults, I want to let you also know that we are doing the Senior Academy again. And registration is open now. The Academy will begin on Wednesday, October the 7th, and will be held each Wednesday in October. You'll have the opportunity to hear from city officials and department heads and find out how to get things done and be more involved. For more information about the Senior Academy, you can go to SSA's website, which is www.seniorservicesalex.org. And again, thank you to our panelists and thank you for joining us. Have a great weekend.